attorney based in. So, as you know, I'm Kelly Keller. I am actually the founder of the Keller Law Firm, and I'm an intellectual property attorney based in Pennsylvania. But because intellectual property is governed by federal law, I'm able to represent clients all over the country. So I have the opportunity to meet with many, many people who come from all different walks of life and all different geographic areas. So that's fantastic. I also have an educational website, kellykeller.com, where I post content about starting and growing a business. A lot of it is heavy on intellectual property, about how to harness your invention. So that's who I am, and that's the stuff that I do. Today, we are going to talk about intellectual property essentials, and we're going to go through 11 of them. So let's start with intellectual property essential number 1. So let's talk about what constitutes intellectual property and why it is important. So many of us think about intellectual property as the creations of our mind, ideas, knowledge, things that we think about, or things that we conjure up. But ideas themselves are not protectable. Nobody can own an idea. You can only own the unique expression of an idea in various types of formats. So when I like to think about intellectual property, I say, let's think about your imagination, your creativity, your ingenuity. We think of innovation, we think of inventions, we think of new ways of doing things. So it's those ideas, but that actually have value in the commercial marketplace and for which exclusive rights are recognized. That's intellectual property. So it's more than just the idea. It's an idea that has been expressed in a way that is valuable in the marketplace. Intellectual property can be extremely valuable, and so it's important to understand it, to identify it, to protect it, and to manage it. So for example, if you're a photographer, you take photographs for a living. Of course, your portfolio is your content. Your portfolio is your property. You own a copyright interest in those photographs. That is an intangible asset. It is not something that you can necessarily touch. It is something that was an idea in the sense that it was your creativity that has been captured in a tangible medium. It's different from a tangible asset like your computer or your phone. So a business will have intangible assets, but it will also have tangible assets. So we want to think about the value of the intellectual or the intangible assets and how they are going to drive business growth. If we go back to our example of the photographer, if you're a landscape photographer, obviously there are many landscape photographers in the United States and indeed around the world. So why would somebody want to purchase your photograph over somebody else's? So it's whatever that unique distinction you're bringing to your art. It could be the way that you shoot pictures. It could be the type of equipment that you use. I mean, there's all kinds of factors that go into the artistry of photographing. That's what makes you different. That's what gives you a competitive advantage. And if somebody were to come in and copy you, or to steal your files, or take your property from you and start to sell it as their own, you would experience significant loss. It would not just be, it would be lost profit, but it would also be potentially loss of market share and even potentially loss of reputation. So intellectual property is extremely valuable, and the loss of it can be very, very devastating. As you've heard the saying many times, I can't get back my good name. So if a brand name, for example, is tarnished, then that is loss of your intellectual property. Your brand is part of what makes you different in the marketplace, and when it's tarnished, it can be very harmful. So let's talk about the 4 core areas of intellectual property. You may recall a couple of slides back when I said that we have imagination and ingenuity and creativity that has value and for which exclusive rights are recognized. Well, the law has created 4 categories of intellectual property that acknowledge and recognize exclusive rights. So when those ideas, ingenuity, creativity, and so on fall into one of these buckets, it becomes a formal piece of intellectual property. You've all heard these terms, but let's be sure that we're all on the same page and understand the differences between trademarks, copyrights, patents, and trade secrets. At a very high level, trademarks identify the source of a product or service. It's your brand names, your logos, package designs, sounds, colors, scents. We'll talk a little bit more about that as the presentation continues. Copyrights are original works of authorship that are fixed in a tangible medium. So that would mean music, art, photos, film, and the like. Patents protect inventions. These are functional things. So they are processes, they're articles of manufacture, they're compositions of matter. So anytime that you take a pill, a pharmaceutical, the technology that goes into that particular drug formulation would probably be something that's a patentable technology. And then trade secrets are actually information that has economic value by virtue of it being maintained as a secret and that you make an effort to keep secret. So the most famous trade secret arguably is the Coca-Cola formula. So it is valuable because it's secret, so competitors don't know what it is, so they can't compete by making an imitation product. So trademarks, copyrights, patents, and trade secrets. So let's jump at a high level for just a moment and talk about why intellectual property is important, not just to you as an individual creator or as a business owner or as one who's scaling a business at this time, but why intellectual property is so important to our economy. We've all heard the phrase, if you build a better mousetrap, the world will beat a path to your door. And every 2-year-old in America knows that's the truth. It's the essence of the American dream. If I can simply do something better or different, if I could invent something that would fix this or change this, then I'll have it made. I mean, that's part of what's ingrained in the American psyche. And why is it that actually matters, and how is it that the American economy, we've heard, small business is the backbone of the American economy. Small business is an economic driver, and innovation, the wheels of innovation are important to our success. Well, let me explain that really there's 3 ways that a nation can grow rich, and it's by relying on natural resources such as oil. Cheap labor, when you keep your labor costs down, then you're able to have a higher profit margin for your products and services, but that's why we hear about jobs being sent offshore, whether that is to India or China or to Mexico, because the populations are such that they will work for a very, very low wage. So you have cheap labor, which helps to drive economic growth. But in the absence of those 2 things, what you have are the creativity of people. And if you have an economic system that harnesses the creativity of its people, you too can drive economic growth. And I would posit that the American economy focuses on harnessing the creativity of its people as one of its primary economic drivers. So you see, you may feel that you're just a small creator, or you're just one person who has an idea or would like to leverage something to make money, or whether that is to do good, whether it's to make profit, whether it's to change the world, or maybe it's just to change your neighborhood. When you do that, your neighbor does it, and everybody does it collectively, it helps drive the economy for our country. So you're part of an important effort. So I'm going to give you a fun historical fact before we actually dig into the meat of today's presentation. In the body of the United States Constitution, there is only one right granted to the American people, and that is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So essentially, the Constitution is telling Congress that you need to create laws that allow people to benefit from their creativity and from their innovation. You may recall that the First Amendment, which would be in the Bill of Rights for freedom of speech, freedom of religion, Second Amendment, right to bear arms, and so on and so forth, those don't come until years after the Constitution is ratified. So interestingly, in the body of our Constitution, we have what has become known as the Intellectual Property Clause, which suggests that celebrating innovation is a deeply, deeply ingrained part of our way of life. Okay, intellectual property essential number 2. Determine if you should protect a piece of intellectual property. It's a question that I receive a lot, and it's a question that can sometimes be difficult to answer because we are creating all of the time. So let's go back to our example of a creative, and let's say that you have a photographer, or let's shift and say that you have a songwriter, and they're writing songs that are very, very prolific. When does it make sense to actually go through a formal protection program, to take advantage of a formal registration program in order to take advantage of broader protections for that work? I say, let's look at a 3-part test. The first is the intellectual property directly related to your competitive advantage? So for example, is the thing that you have created, is it something that makes you different from others? Is it something that if you are actually going to bring to market would distinguish you from other people? Sometimes we create things that are interesting and they may have sentimental value, such as, let's say, a mom that writes the children's stories, which is really just sentimental for her kids, but it's not something that would have marketplace value. While that is technically her intellectual property, if she's not engaged in any type of commercial activity or interested in marketing that in any way, then it may not be relevant to competitive advantage. So I say, let's ask that question. Secondly, does that piece of intellectual property, so that trademark, that copyright, that patent, or that trade secret, actually have value in the commercial marketplace? Is it something people will pay for? And are you willing and able to enforce your rights? So it's important to understand that with the intellectual property right comes a benefit, but also comes a burden. So it's like owning your house. You own a piece of property, you own a piece of real estate. You have the benefit of owning that home for all of the obvious reasons. You have a safe place to stay. You have the ability to create whatever type of environment you'd like to live in for you and for your family. But you also have the burden of maintaining it, of paying a mortgage, of paying taxes, of locking your doors at night, and keeping the inhabitants and the things in it safe. That same logic applies to intellectual property. It's your responsibility to ensure that it is properly maintained and that others aren't infringing on your rights. So if you believe that somebody is misusing your brand name, it is your responsibility to enforce those rights. There isn't a proverbial intellectual property police out there that is going to do that for you. Now, there are lots of strategies and there's tools that we can use to help us do that, but it is your responsibility as a property owner. So if protection is worth it, does it make sense to pay the money to get this stuff registered? Ask these 3 questions, and when the answer is yes, then by all means, it's time to move forward. Intellectual property essential number 3. What are the 4 major forms of intellectual property? Start with patents. So essentially, what does a patent do? A patent is a grant from the federal government. It essentially says, the government says to an inventor, if you disclose your invention to us and we can make it available to the public, then in exchange for that, we are going to give you the exclusive right to make, use, and sell it for a limited period of time. It's essentially a monopoly that says if somebody else wants to make, use, or sell it during that period of time, they're going to have to pay you for that. So it's essentially a contract between the government and an inventor. It's an inducement for the inventor to disclose all of his or her ideas, but not just the ideas, but how to actually make something. We'll learn a little bit more about those details shortly. What does a patent actually protect? Well, it protects functional items they're useful, they're novel, and they're non-obvious. Non-obvious means that it is something that is not obvious to one of ordinary skill in the art. So if you're an inventor and you're a chemist and you come up with some type of a process that other chemists who are similarly skilled would be able to come up with without a lot of thought or consideration. I call it, does it pass the test? Well, duh, I could have figured that out. It has to do more than pass that test. It has to be non-obvious, which just shows that it has a higher level of ingenuity than what someone with ordinary skill in the art would be able to protect, or would be able to create, rather. So how long do patents last? Well, interestingly, they last for 20 years from the date that you file it. So if you file a patent application on January 1st, 2018, then your patent will actually be, assuming that it actually issues, then it will be valid until 2038. And I should also mention that when you file a patent application, you don't own anything until the patent is actually granted. So when we say there's no rights during pendency, we mean that you don't own a patent until the patent is actually granted. It may take a year to review the application. It may take 4 or 5 years to review it. But the patent doesn't vest until you've actually received the grant. Okay, let's move on to trademarks. So what does a trademark do? A trademark is a source identifier. It distinguishes one manufacturer's or merchant's goods from those offered by others, and it gives the manufacturer or merchant a competitive advantage. When you walk into the store, there is a reason you choose one brand over another. If you're buying spaghetti sauce and you're a Ragu fan, you're like, you know what, I like it, that's exactly what I want, and I'm buying it because I know, trust, and like that particular brand. If you say, you know what, nope, I like the Nature's Promise brand, I would prefer that. So essentially, the trademark is the brand name, and it's how consumers recognize you and understand you. What does a trademark protect? A trademark protects words, phrases, symbols, or combinations of them, and even designs and shapes, such as we see here, the shape of a Coca-Cola bottle. A trademark can even protect colors, sounds, and smells. You've heard of UPS brown, or here there's an example of Tiffany blue. Consumers see that color and they associate that color with a particular product and service. So that color is actually serving as a source identifier, and therefore is functioning as a trademark. How long do trademarks last? In perpetuity, that means forever. As long as the trademark is being used commercially and it's in continuous use, and if it's a registered trademark, that you maintain that filing. You have to renew trademarks every 10 years. So Coca-Cola, for example, has been in business for more than 100 years. So the trademark didn't expire just because a 20-year period ran out. So long as it's being used commercially and consumers are creating an association between that mark and a product, it can last. So we can go on and on and on. As with patents, trademarks, the scope of them is national. So trademarks are territorial. So a trademark in the United States is only valid in the United States. If you want to have trademark protection in Canada, then you'd actually have to take advantage of the trademark law in Canada. So a trademark registration or a trademark that is legally valid and enforceable in the U.S. is not necessarily valid or enforceable outside of the country. Copyright. So what does a copyright do? Well, unlike a trademark, which is a source identifier, or a patent, which protects a useful or functional item, a copyright protects an original work of authorship that is fixed in the tangible medium. So, for example, the moment you put pen to paper and write a story, the moment that you actually type out a blog post, you actually take a photograph, the moment that you create something and fix it tangibly, That is what a copyright protects, is that authorship that's been expressed in a tangible medium. Remember that you cannot own ideas, only unique expression of them. So there isn't any way to protect something that's just simply residing in somebody's head. We have to actually see some type of evidence of it. So federal copyright registration provides a sort of a bundle of rights, or I should say the copyright law provides a bundle of rights to the creator of an original work, and essentially it's a bundle of 5 rights. You have the right to exclusive right, meaning you can exclude others from doing it, so exclusively have the right to copy it, to distribute it, to make derivative work. So this sort of, if you've written a book, a derivative work would be creating a screenplay and then taking that screenplay and actually creating a movie. So the new work is derived on something else. And actually, so we can reproduce it, we can copy or reproduce, distribute it, make a derivative work, but also to publicly perform or publicly display that work. And the most common understanding of a public performance would be singing the song at a concert, or going to a play and you're actually performing the script or performing choreography. A public display would be something like a sculpture or in a museum where you actually have something hanging on the wall. Similar to patents and trademarks, copyrights have national scope and last for the life of the author plus 70 years. So they last a really, really long time. And finally, trade secrets. Trade secrets, as we know, this is information that has economic value by virtue of it being kept a secret, and that you take reasonable means to protect it. Trade secrets, just like trademarks, can last forever, so long as it's protected, or essentially until the secret is exposed. So something like the Coca-Cola formula, as I mentioned, one of the most famous trade secrets, and it is kept secret. And Coca-Cola takes reasonable means to keep it secret, meaning they keep it under lock and key, they limit who has exposure to it, and so on and so forth. So again, just because something it's business information that you keep secret, it may or may not rise to the level of what's called a trade secret, but you'd be surprised at how broad that protection can actually last. Intellectual property essential number 4. There are 4 types of patents, so I would like to briefly introduce you to these, but we won't spend a lot of time because this is an entire webinar in and of itself. But I want to introduce you to the terms so that you understand them as you're considering your own innovation and what type of intellectual property you may have. So essentially, there are 4 types of patents: utility patents, design patents, plant patents, and covered business method. So a utility patent is going to protect a process or a method, a machine, such as your printer, an article of manufacture, such as a pencil, a stapler, a composition of matter like a pharmaceutical product, something that's functional. A design patent will actually protect an original or an ornamental design for an article of manufacture, such as the Coca-Cola glass bottle or the Croc sandals. Apple has design patents on the shapes of its iPhones and other products because it's not actually a part of the function of the item, but it is certainly important and unique to that particular business. Similarly, new varieties of plants that are created can be protected by patent protection. And covered business methods, there's a lot of litigation about the scope of covered business methods. But for example, the Amazon one-click ordering process is a patented process, as well as Priceline's reverse auction. So it's a way of doing business. You see a lot of this sometimes in the financial services industry. Patentable subject matter and 3 patentability tests. So essentially, something has to be novel, useful, and non-obvious for it to be patentable. We spoke about that briefly in the introduction, which essentially is saying that if something is ordinary, you aren't going to get that limited monopoly. You're actually going to have to do something that is new and different. Let's also mention that an idea is not patentable, an invention is patentable. So until you take something that is a conception in your mind and you've reduced it to practice, which means you have to make sure that it works, it actually functions, you've created a prototype, you don't have an invention. So it's important to say, I have an idea, can I patent it? No, you cannot patent an idea. You can patent something that meets the patentability standard of novel and non-obvious, and that has been reduced to practice. That's something that is widely misunderstood, and I think it's important to make sure that you're aware of that. And finally, that patent grant, what it does is it excludes others from making an invention, using an invention, selling it, offering it for sale, or importing it. So essentially, you have true exclusivity over that invention for the period of time that your patent is active. And if somebody else wants to make it, they're going to have to pay you for it. And so that's the concept of royalties for your invention and so on and so forth. Okay, intellectual property number 5, the 4 types of trademarks and the requirements for federal registration. The first 2 are trademarks and service marks. They're relatively self-explanatory. Trademarks actually represent goods. So Nike is a trademark for shoes or sports apparel. Those are products. Service marks are marks that represent services, such as like AT&T for communication services or Google for search engine services. We also have what are called collective or membership marks and certification marks. So collective or membership marks essentially are something that if you use, it suggests that you are part of some type of a membership organization or bargaining collective or something like that, like Realtor or Teamsters. And certification marks are actually not used by the company that created the mark, but it's used by users to say their products actually meet certain quality standards. And there's some examples there on your screen. So the most common trademark types are names, words, Coca-Cola, McDonald's, AT&T. Symbols also function as trademarks. The Apple logo, the Nike swoosh, and of course the Olympic rings. Or a combination of words and symbols, or some type of a stylization, which you can see Dell or Skype or BMW, letters and designs. Slogans, just do it, what's in your wallet, taste the rainbow, all well-known slogans. But less common trademark types and often of interest are the fact that you can trademark or you can receive trademark protection for colors, shapes, sounds, and scents. So I mentioned Tiffany Blue and UPS Brown earlier in the presentation. Similarly, Coca-Cola Red. So that means that no other beverage company can use that same color red in their product packaging. Because as a customer, if you were to see that from a distance, you may be confused into believing that somehow that beverage is associated with Coca-Cola or emanates from a common source. Shapes, very self-explanatory there. I love the Pepperidge Farm goldfish. Sounds, the NBC chimes. The sound of Darth Vader breathing is actually a trademark. The Jolly Green Giant Flap, and for those of you who are Law and Order fans, that don't sound, that's part of the scene transitions, is actually a protectable trademark. And most recently in news, the scent of Play-Doh has received federal trademark protection, and the scent in Verizon stores is also a trademark, which is, the question is, can a consumer associate that particular scent with a product or service? And the answer is yes. I want to highlight a point very briefly on trademarks and trade names. Trade names also being business names. Especially when you're starting and building a business, it's extremely important to understand that trademarks are brand names. They might or might not be the same as your trade name or your business name. Business names, when you become, whether you're a sole proprietor, a limited liability company, a corporation, or a partnership, whatever you name your business, that is governed by and regulated by state laws. Trademarks, on the other hand, are regulated by federal laws. So Nike Inc. is the name of a corporation. It is also the name of their primary trademark. But in another example, Tylenol is a brand name of a product that is manufactured by McNeil Consumer Products. So the business name is McNeil Consumer Products, but the brand name is Tylenol. And what is important in the marketplace, people buy things based on brand name, not by company name. Nobody cares who McNeil Consumer Products is. They care whether or not it's Tylenol and if it's going to work or not. So all of the consumer goodwill is in the trademark, not necessarily in the business name. Sometimes they can match, sometimes they don't. But when you're choosing a business name and a trademark, it's important that you understand whether or not that business name is also available for use as a trademark, not just a business name. So what actually can you receive trademark protection for? And this is an important point and something I want you to pay close attention to as we finalize and sort of wrap up the trademark section of this talk. You can only receive trademark protection for marks that are distinctive of the products or services. That means that the relationship between the mark and the product or service is attenuated. Essentially, something that is distinct. Its intrinsic nature serves to identify a particular source. So if I were to say, hey, that's a chair, that is not distinctive of a chair. If I were to say, oh, that is a certain brand of chair, now that brand name would be distinctive. So for example, if we think about a cell phone, oh, okay, that's a cell phone. Well, the word cell phone is not distinctive, it's the name of the product. But if I say it's a Samsung or it's an Apple, that is distinctive because it helps me understand. So essentially, only marks that are inherently distinctive or that acquire a distinctiveness can actually be protectable as trademarks. What do I mean by that? Well, fortunately, the courts have given us some excellent information on, and excellent guidance on what is a protectable trademark versus what is not. And we call this a spectrum of trademark distinctiveness. So words that are coined or fanciful, they're completely made up, and they don't mean anything other than a trademark, those receive your strongest protection, such as Google or Kodak. The words don't have any meaning or relationship to the underlying product or service. Arbitrary marks are also strong marks. These are real words that are used in an arbitrary manner. So for example, Apple for computer or Camel for cigarettes. Apple means one thing in one context, but when applied to products or services, it's something else. It's the arbitrary application that creates distinctive meaning. Suggestive marks are those that suggest some type of an association with a product or a service, such as chicken of the sea for tuna. The courts say that the consumer has to do some type of like a mental gymnastics to think through what might it actually mean. But I call it sort of, those are the clever marks. And then the unprotectable marks are those that are descriptive marks or those that are generic. So here we have some examples of coined, arbitrary, and suggestive marks. And let's move here to those that are descriptive or generic. So marks that actually describe a product or service, so such as Best Buy. It's you go to Best Buy and you're going to get the Best Buy on the market. But what happens is over a period of time, when consumers come to understand that a term that is at once descriptive has a second meaning as a distinctive trademark for certain products or services, consumers are able to distinguish the difference between the descriptive meaning and the trademark meaning. It acquires distinctiveness and then can become protectable. And generic terms, which are the name of the thing, are never protectable and cannot be owned as trademarks. Trademark rights arise from commercial use. So as you begin to actually use a mark in commerce, you begin to accrue trademark rights in it. But those rights are limited to the geographic territory where you're actually using the mark. If you want to expand those rights nationally and you want to achieve a greater level of protection, then you should take advantage of the federal registration process. And like with any piece of intellectual property, think of the registration like a title to your car. So ownership is 9/10 of the law. Having the car, having the key, having it in your driveway makes it yours, but it is impossible to prove it is yours, and it's very difficult to do business with it without the registration. Okay, intellectual property essential, number 6. What is eligible for copyright protection? So we'll just run through this briefly because we've spoken of it multiple times in the presentation so far. So it's essentially those creative ideas that are expressed in a tangible medium that are creative. So in the sense, it's some basic level of creativity. You can't copyright a set of facts, for example. It has to have some modicum of creativity. That's not an aesthetic judgment. It's more of an objective judgment than a subjective question. Copyrights give us 5 exclusive rights. We've spoken about those earlier. It's this bundle of rights. It's the exclusive right to copy, to distribute, to make derivative works, to publicly perform, and publicly display. They're very, very powerful rights, and they can be enormously valuable. This is how singers become wealthy. This is why movie stars make a lot of money. So I have a quick slide here on what is not copyrightable. We talked just a moment ago about a sort of modicum of creativity. So for example, ideas or concepts or discoveries are not copyrightable. So there are some things that you won't be able to have any exclusive protection for. Let's touch base briefly here on the benefits of federal copyright registration. You may have all heard and understood that a copyright vests the minute you create an original work. So you own the copyright in something the minute you actually create it. However, it's like that title to the car. In the United States, you cannot legally enforce a copyright that has not been registered with the U.S. Copyright Office. So yes, you own the copyright, but you do not have the ability to enforce it. Copyright is federal law. You have to sue in federal court. You cannot sue in federal court without a registration. So essentially, registration is a prerequisite for enforcement. I'm going to go through these slides very quickly because I know that we want to wind down and have plenty of time for our questions. But I want to just briefly mention, when you have a trade secret, it's important that you take very, very practical means to keep it secret. If you have employees, if you have independent contractors, then it's extremely important that you have them sign non-disclosure agreements, that you have passwords on your computers, that you are actually very practical in the way that you are looking to keep that information secret. So trade secret disputes, a lot of times it's when somebody works for you and then they leave and they want to take all of the information that they have learned from you during the course of their employment with you. You want to restrict their ability to go into competition with you, and that is when we see most of the trade secret disputes. This doesn't happen as much when you're just starting a business out, but it is important to be circumspect about who you're sharing your ideas with. I have a slide here, and you will all be getting the slide deck, which if you are looking to protect trade secrets, that you will be able to have a trade secret protection program in place. It doesn't have to be fancy. It just has to be there. So I just want to leave you with how we measure the value of intellectual property. Make sure that you audit your intellectual property, identify what you have. We don't even know if it's valuable if we don't know what we have. So you want to identify any existing inventions, any brand names, copyrights. identify your work in progress. So take stock of what you have and then determine whether or not something is actually being protected. And remember, if it passes that 3-step test, then you want to move forward and seek counsel to learn how to actually protect it. And finally, let's wrap up on talking about how intellectual property can create monetary value and increase your competitive advantage. It can help you attract investors, attract and retain top talent, achieve cost savings. You can charge more. Luxury brands, we all know about it. What makes that one worth more than that one? It's the brand name. That's very, very common, common parlance. You're able to negotiate better contracts. You protect your market share. You can develop new revenue streams, for example, by co-branding or letting somebody use your brand name on their product, licensing it, and so you're simply getting paid for using that particular brand name. And additionally, it can also create competitor barriers to market entry. So if you're enforcing a trademark, you're going to keep them from being able to adopt the same or a similar mark for products or services that could go into competition with you. So with that, we're going to wrap it up and move into the question and answer time frame. And I know we covered an awful lot of material, but that is a very high-level view of intellectual property, sort of at that 101 level. And I hope that now you have a much better understanding of the elements of intellectual property, the core areas, and where your innovation and your ingenuity and creativity may fall. So thank you so much for your attention, and I look forward to answering your questions.
Okay, Kelly, thank you so much. We will go ahead and start the Q&A portion of our webinar. I'm going to be reading the chat questions that our participants have been sending in. Please continue submitting your questions. Yes, and if you all will continue submitting your questions in the chat feature located on the left-hand side of your screen, we will address just as many as we can in this time remaining. We've received a lot of great questions, more than we will be able to touch on today. So I would like to encourage you to connect with a SCORE mentor after today's webinar who can help you apply these strategies that have been talked about today and help you with your business needs. So I will be posting a link at the end of this session that you can request and seek out a mentor to assist you. All right, so with that, let's go ahead and we'll move into these questions. Kelly, our first question, this comes to us from Angela. She'd like to know if it's necessary to trademark your business name, and if so, what if you have been operating for a year? Is it too late to get the mark?
That is a great question, and the answer is no. It is not too late to federally register your trademark. You can federally register your trademark at any time. What is important is remember that your trademark rights actually arise from your use of that trademark commercially. So when you start to sell products or services or offer products and services under that brand name, the trademark right is actually being created as you do that. The federal registration process gives you what I'm going to call like a legal title to that, so it takes those rights and expands them to ensure that they are nationwide and gives you a very streamlined way to enforce your rights in them. So it's a great question. It is never too late to file a trademark application, and it is always wise to do so because it gives you a much broader set of tools to ensure that nobody is infringing on your name.
All right, and our next question comes from Talia. So if you're developing an online class, can you copyright the information or the research or the curriculum that you have developed?
Absolutely, and that is a very common practice, and it is important practice because that is your creative work. So as soon as you have created that curriculum and you have created all of the images, all of the text, the lessons, and so on and so forth, that is your copyrighted content, and it makes sense for you to register it so that you are able to enforce it if you need to. That is the value that you are selling to your students. They are purchasing your copyrighted content. They're purchasing access to it. So it's a great question. The answer is yes, and highly recommended that you pursue formal protection of that. You have broader array of remedies if you need to exercise them.
Okay, our next question comes from Thalia, who'd like to know if a recipe can be protected by intellectual property.
So essentially, recipes would be protected primarily by trade secret. That is information that would be like a secret sauce, literally and figuratively. So you would need to keep that secret, and you would need to be very careful about who you disclose it to, and ensure that if you do disclose it to anybody, that they are contractually bound not to disclose it should they leave your employment, or ensure that they have limits on them, usually by a non-disclosure agreement or some type of an agreement that says they cannot tell anybody about it. So you can protect it as a trade secret. Because remember, we want to keep it secret, and it has economic value because it's secret, not because it's known to the public. Good question.
Okay, our next question comes from Rashonda, who says that she's been using a brand name since 2012 and was contacted by someone that wanted to work with her. They filled out trademark paperwork and didn't include her name. How can she object a trademark?
That's a great question, and it depends on where it is in the process with the U.S. Patent and Trademark Office. So once a trademark application has been filed and it has been approved by the Trademark Office for registration, it goes through a period of what's called third-party publication. So for a period of 30 days, after a trademark has been approved by the Trademark Office, it is published in an official, in what's called the Official Gazette of the U.S. Patent and Trademark Office, and anybody who believes they will be harmed by the registration of that mark can lodge an opposition against it. So there's actually a formal procedure with the U.S. Patent and Trademark Office. If you are unable to take advantage of that small window of time, you can always contact the applicant or the person who is using the mark directly and request that they cease and desist continuation. So you either contact them privately or you take advantage of the system set up with the U.S. Patent and Trademark Office. But it is something you can do, and it is something that is important for you to do. And it is important for you, in this case, I'm going to say, to get professional help on how to do that, because it can be a little bit tricky. Great question and an important one.
All right, our next question comes from Jahina, who would like to know how much you have to pay for a patent.
So patents can be extremely expensive. You will pay, there's two sets of fees that you're going to pay. There's fees that you pay to the U.S. Patent and Trademark Office for filing fees, and depending on the size of your business, the fees are on an adjusted pay scale. So they do have smaller fees for what they call micro entities. So there are filing fees that are mandatory paid to the government, whether you file an application on your own or with help. The other set of fees that you will pay will be to whoever is going to help you prepare the application. If you prepare it on your own, of course, there would be no fee. If you use a document filing service like a LegalZoom, you will pay them a lower fee. If you use a patent attorney who is qualified to write the application, you will certainly pay more, but you will get what you pay for. So you should budget anywhere between $5,000 and $10,000 to get a patent in today's day and age. Very expensive, not the easiest process, certainly doable. But there are ways to do it, like using a document filing service, to do a lot of research and understand what you're getting, and get some guidance and get some help before you go down that road. But it is not an inexpensive venture. Another great question. They're all great questions.
Okay, our next question, it comes from Ashish, who asks, if I develop or design a process or product at work using their infrastructure, so their computers and their internet, do I own the IP on that process or product?
That's also a great question. And a lot of that is going to depend on your legal relationship with the employer. If you are an employee working within the scope of your employment, then they're going to own the invention. You aren't going to own the invention. If you are not working within the scope of your employment, then chances are you will be able to own the invention. A lot of employers who have employees working in innovative spaces will require you to sign what's called an invention assignment agreement to clarify that they own the invention. They are essentially paying you to be there to conduct research and development. If you are using their equipment, but it is on your time and it is not infringing on, or I should say, on their time or on the money that they're paying you, then that would be a more nebulous question. Simply use of a computer does not automatically transfer an intellectual property right. But I would strongly encourage you to get clarity with your employer if that is the case, because you don't want to have any type of litigation or any type of a contentious issue with your employer. It's a good question. If it's within the scope of employment, assume it is owned by the employer. That is a very simple answer to a complicated question, but I think that's the gist of it.
Okay, so I've had several folks ask questions around the cost for copyrights. And do you have to pay for a copyright? Is it as expensive as a patent?
That's a great question. The answer is no, fortunately. So you will pay a filing fee to the U.S. Copyright Office when you file an application to register a copyright. And the filing fees currently range approximately between $35 and $55 per application. That is the filing fee. If you file it on your own, of course, then there is no fee for the preparation of the application. And again, you have the option, there it is, to DIY or to use something like a document filing service. It's not legal services. They're not giving you any legal advice, but they're assisting with the filing like a LegalZoom. You pay a lower fee, or you can use a copyright attorney who will charge you a little bit more, but they're not, you're looking at a few $100s, not a few thousands of dollars. Copyright is significantly less expensive to protect.
All right, our next question comes from Frank, who would like to know if you have any thoughts on Creative Commons licenses. So, for example, if someone is seeking to add music to a presentation or as an intro to a video, what would you say is important to consider?
It's a very good question, and I have a lot of thoughts on Creative Commons, but for purposes of this forum, let me say this. I think that Creative Commons has created a very practical way of sharing information online where people are trying in good faith to share and use information without infringing on another's rights. But I will say this, Creative Commons is not created by the government. It is a private licensing scheme, and they're not enforceable. They're not the copyright law. So I can put a Creative Commons license on something that I've created, but there isn't anybody questioning or examining whether or not what I've created is actually copyrightable or whether or not I stole it from somebody. So if you use my Creative Commons license for something that I have put out there, represented, it's available for license, and it wasn't, you're still liable to the original or the true owner. So that's the challenge with Creative Commons. I'm going to tell you, for all intents and purposes, most of the time, Creative Commons licenses, they work, they're useful, and they're helpful, but they are not enforceable, they are not examined by anybody, so people are making a personal judgment as to whether something is licensable or not. So I have mixed feelings about it, but then again, anything that is sort of a private process to try to facilitate implementation of the law is going to have inherent flaws in it. But as a general rule, I think it's a good system, but you need to be careful and make sure that whoever is licensing it truly owns the work.
All right, our next question comes from Perry Avett, who says that when he registered a trademark for his brand in the U.S., how can he still have the same protection globally? Does he have to register for every country?
Yes, that is a great question, and the answer is yes. Trademark rights are territorial. They are only protectable and enforceable in the country where they are used or where you have filed for protection. Here is the good news, is that there's an international treaty. There's a couple of international trademark treaties where essentially approximately 180 countries have said, let's create a filing mechanism that will make it easier for people to achieve global trademark protection. So, for example, in the European Union, you can currently file one application and receive protection in all 28 member countries. So you don't have to necessarily file country by country. You can file in various regions and have some broader protection. But you do have to have a home country registration. So if you file initially in the United States, that would be your initial registration. And there are a couple of different ways that you can approach international registration, but you do have to file country by country or region by region in order to achieve protection in those jurisdictions. It's a good question, and international filing is important to get some guidance and advice on so that you understand exactly what you're getting and what this right strategy would be, because trademark laws do differ across the world. Very good question. And I'm going to throw out two terms for you so that you can Google them and be able to follow up. That you can use what's called the Madrid system, or filing according to what's called the Madrid Protocol, or you can do what's called national filings under the Paris Convention. I'm not trying to explain those, but that way you have those words and you can do some additional research and understand there's two different ways or approaches to international filing. And sometimes taking advantage of both of them is the right strategy for you. Very good question.
Okay, and I think that we have time for just one last question. We can squeak it in. This one comes from Michelle, who would like to know if there's a relationship between copyright and plagiarism. Can something be plagiarized if it hasn't been copyrighted?
The answer is yes, and I'm going to give you a very quick. Let me give you a quick explanation. So something that is copyrighted, that means it's still being protected under the copyright law. So you may recall the term of copyrighted life of the author plus 70 years. So copyright infringement is taking somebody else's work and using it as if it were your own. Obviously, you're not giving credit for it, but you also don't have permission to use it. Plagiarism, on the other hand, is simply not giving somebody credit. So it's not, you don't need permission from somebody to quote them or to make reference to their materials, but you do have to give credit. If something is no longer under copyright protection, it is now in the public domain, you can't infringe on it because it's no longer protected, but you still can plagiarize. For example, Lincoln's Gettysburg Address, it is not protected by copyright. The copyright term has long expired on that, but if you quote it and fail to give credit, you have plagiarized. So we see this happen a lot with historical quotes or historical works. Those from the 19th century, we could pretty much say anything done prior to 1923 would be in the public domain. So essentially, plagiarism is failing to get permission, is failing to provide attribution, and copyright is not only not providing attribution, but also not getting permission to use something that's currently protected. There is a lot of overlap, but they are slightly different. Good question.
Okay, so those are all the questions that we have time for today. If we did not have a chance to address your question, again, I'd like to encourage you to connect with a SCORE mentor today after the webinar. I'm going to post a link here in the chat box for you to access further information. And if anyone out there attending today is interested in becoming a SCORE mentor, I'm putting a link in here as well that you can get further information regarding that. Just a reminder that the link to the recording of this session and the presentation slide deck will be sent in a post-event email.